Good afternoon, everybody. This is Immigration Attorney Irene Weisman. Today is Tuesday, June 10th, 2025. I apologize. I know I haven't gone on in over a week. It just has been incredibly busy. I was supposed to have 3 trials last week. Thankfully 2 were moved and I just had 1, but it was a really big one, and because I didn't know the rest were going to be moved, I was preparing for all 3. So it has been a bit crazy. The one that I did have went very well, incredibly well, and my clients and I just couldn't be happier. It was a Russian political opinion claim, which I have won and no appeal by the government. So incredibly happy with the result. Okay, as far as news, travel ban. Okay, so there is a travel ban in effect, and there are 2 categories. One is like a full travel ban, and that's Afghanistan, Burma, Chad, Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, and Yemen. Okay, so if a person is outside of the United States, they are not an immediate relative, and they are not an asylee or refugee, or they do not have an AG or other like NATO related visa, or they're not coming in as an Olympics athlete or coach. A few other exceptions, so that's full ban on on individuals from those countries. And then we have a partial travel ban, okay, and that's Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. I have not personally seen this play out yet. I do have a colleague who had a client from Venezuela, and their fiancé visa was rejected due to this. Okay, so just be mindful that this is out there, and obviously speak with your immigration attorney if you have a case in process from outside, from a person who is from one of these countries. And really what I mostly wanted to discuss today was American Immigration Lawyers Association had a liaison session with ICE, okay, Immigration and Customs Enforcement. So this meeting occurred several weeks ago. So I just have the notes from that meeting, and I wanted to discuss a few updates that sort of came up from that meeting. Okay, I'm not going to discuss everything because a lot of the stuff is logistics and really meant for for lawyers, but some of the things could be interesting for you, my listeners. As obviously this is a big thing right now, and very much in the news, very much hot topic, so to say, right? So there have been increased amounts of arrests or detentions for people that are on order of supervision. So what I'd like to say is that if you have to go in for an ICE check-in now day and age, I would really have an attorney present with you, okay? Because it's just the times we live in. You should know what to expect, and you should have an attorney there with you. You are allowed to bring an attorney there with you. An attorney is allowed to stay there with you at all times. The only time they would ask the attorney to step out is if they are in fact going to detain a person, and that process of the actual detention, for that, they will ask the attorney to step out. But for everything else, if there's any types of questioning, if there's anything like that, check-ins, paperwork, questioning, you are allowed to have an attorney with you present at all times. Again, the only time it's not allowed during the actual detention process, okay? Unfortunately, I was present during the detention for one of my clients a couple of months ago, and they did allow me to stay and to be there. It's just that they did ask me to step out for the actual detention. An attorney may not necessarily prevent the detention from happening, okay, especially if it's a mandatory detention type of a case, but you do definitely want to have an attorney there with you. They do, at least at New York ICE office, they speak many languages, but if you wish to bring an interpreter with you, you can. Not necessary. They usually have somebody, and then you can always get somebody over the phone to interpret. But they did indicate that you could if you wanted to. Once again, if detention does happen, that interpreter will not be able to be there during the process of the actual detention. However, they can be there with you to help you interpret if you don't understand something. Use of electronic monitors. Again, nowadays, if you walk out with an electronic monitor, I'd say, be happy that you didn't get detained, but definitely an increased risk. And they're saying that maybe you lost your case and the case went up on appeal, and they now consider a person to be more of a flight risk, then they may want to place an ankle monitor on that person just for that person, for that reason. Email ICE check-ins, no more, okay? So you can no longer check in for your ICE appointment via email. They want you to come in, okay? And they were very clear about that. If for some reason you did miss your scheduled appointment, they do want you to email them and indicate that you had an appointment, you missed it. You better have a valid reason, okay? If it's, I overslept, or, something unreasonable, there could definitely be consequences. They said that they would entertain the excuse on a case-by-case basis, okay? But if you had an ICE check-in, you missed it, definitely email your deportation officer, okay? Let's see. I went through this. So I'm going through my notes. There have been instances where people that go in for ICE check-in, oftentimes they have paperwork, right? The I-220A, where you have a date where you were supposed to check in, and the officer signs off on it, and they will put the next date where you have to appear. There have been instances where the officers have not been checking that off. They really should be, and if yours wasn't, please ask, please give it to them, make sure that it's filled out, okay, because some people actually need it for employment authorization. And in general, it's proof of compliance, okay? For people that have already been detained, there have been a delay in a system called ICE Detainee Locator, and sometimes it takes several days for the person to actually show up in there. So, a loved one, family member, friends can know, attorneys even can know where that individual is, but there have definitely been delays. So they are asking, usually it's within 72 hours. Sometimes when it falls on the weekend, there could be delays. They're asking that, you basically bear with them and give them time to process a person, but within 72 hours that, the information should appear, okay? Stay of removal, or I-246. So basically that's, for a person that's detained and that's up for immediate removal. They will entertain it, but very rarely nowadays, okay? So they're saying it's like a life or death situation right now, but it can still be submitted, and your attorney will know how and what to submit and where to submit it. But definitely very difficult to get nowadays, okay? So my biggest takeaways from this particular meeting is that there's no more email check-in with ICE. That's very important. They want to see you. And if you missed the appointment by any chance, definitely email, let them know, appear yourself and let them know. There better be a valid reason as to why you missed the appointment. And if you do have a nice check-in appointment coming up, previously people would just, there were always people that took an attorney for an ICE check-in, but many of my clients, for example, would used to go in by themselves for for the last, I don't even know how many years. But now I would say consider hiring an attorney to go in with you for that ICE check-in, because it's just, the times we live in right now, okay? It's just safer that way. You should know your rights and you should know what to expect. Maybe nothing. Maybe it would be, a regular check-in, okay? But maybe not, okay? Especially if you have criminal arrests, criminal convictions. Don't go there by yourself, okay? Have an attorney present, have the dispositions. There are some things you should, or at least I advise people to do before they go in, sign G28, power of attorney for documents to a loved one, in case you do get detained and your family is going to start working with an attorney on obtaining documents. That power of attorney would be super helpful, okay? And in general, there's just, things to do to prepare that, if these things would have been done, could make things much easier for friends and family to obtain, because a person is detained, right? So if you have an old order of removal, if you have criminal convictions, see an attorney. If you already have an attorney, just talk through this ICE check-in with them, and definitely have an attorney present with you when you go in for that ICE check-in, okay? That's it for me for today. This is Immigration Attorney Irene Weisman, and I will be talking to you soon. Have a great day, everybody.